I'm Jim Krause from Long Shot Golf. Today is another Tuesday Tidbit brought to you by Regroup Advisors. Today's topic will be the place for a patent in your product cycle. I start with that operation because whenever you're developing a product or building a new business or service, the topic of patents always seems to come up first. I've found over the years when talking to people who've tried to do products, including our own efforts to patent something, that sometimes you need to not fixate on a patent right out of the box. You really need to take the time to prove that your concept is viable. Start off by looking into, of course, research on other products, making sure that there's nothing similar on the market or something that can do what you're doing in a different fashion and you're not really adding anything to the conversation. This takes a lot of time, and it also takes a lot of time to research possible names because those get to be problematic. But you mainly need to prove your concept before you start considering how to protect your concept. And that leads to a direct question as far as how you're going to sell the product, distribution channels, things of that nature. These are all things that need to be ironed out. Too many times I'll have people call or submit things to me. I get them all the time, and they'll be, we need a non-disclosure. I'm getting my item patented. I don't want to disclose it until I get a firm, whatever, detail. And sometimes that's really putting the cart before the horse, because I think there's a vast misunderstanding on a place for a patent in a small business. Basically, a patent in a small business is only as good as your ability to defend it. And that's why I say it's not really the first step. I had instances years past where things were done that were basically knocking off our patent or abusing our patent. And I found out the hard way that it's not what some people believe. It's not an automatic way that you can make a phone call to somebody or a government agency and tell them to stop somebody from doing what they're doing, and then you're compensated and everything goes away. We were basically told that it would cost more than our gross sales for the year to file a suit, because it has to go to court. You have to prove it. They can file a suit back. Anyway, it's a long process. And basically, for a small business, a patent will do as much as keep the small guys away. It will give people pause with trying to knock off your product. It will give you protection at some point in the cycle, but it isn't really the place to start. And there's too many agencies out there that will take money to assign that as the first thing you need to do and then submit products. You really need to make sure you're ready to get that your product is viable, that you can make money with it. Because if it's not going to do any volume, you would never have the dollars needed to defend a patent anyway. If you get those things answered and you feel comfortable that you have a product, you have a manufacturing way to take care of the product or service, and you feel you can market the product, then is the time to look into a patent. And I've recently found with some of our new listings that best place to start with that is a provisional patent. Provisional patent is a very simple device, can easily be done by a single small business person. As an individual, you wouldn't absolutely have to have an attorney. It's a simple way to file the basic idea, to lock in the date when you developed it. And at that point, you have roughly 12 months to freeze the idea in place, so to speak. And if it is viable and you're going to go through with it, then you go through the entire utility patent process, which you probably would need an attorney for, and it's a little more expensive, and you do the filing at that point. But a provisional could be a good place to start. Non-disclosures are also a possibility, but they tend to scare people away from talking to you about anything. So you got to keep in mind that start with the product itself, work through all of those steps, which we'll go through in future podcasts, and from there, then go ahead and seek the legal protections that are required. Obviously, you don't want to disclose too much while process is up front, but you should be able to get enough idea of your viability by just doing the research yourself and not really contacting anybody else. Hopefully that'll give you a place to start. You won't spend money you don't need to spend, and you won't feel that you're getting protections that you're not really getting. And it's not a negative exercise, it's just common sense. And that's been another Tuesday Tidbit presented by Regroup Advisors. Hope to talk to you again soon.
If you've enjoyed this episode of Business Plain and Simple Tuesday Tidbits by Regroup Advisors and don't want to miss future topics, well, like and follow us wherever you get your podcast. Interested in learning how Regroup Advisors can help your company? Contact us at info@regroupadvisors.com or online at regroupadvisors.com.